Today, let's talk about the 4 favorite tricks cops like to use during the DUI and DWI stops to arrest you. Number 1, the defendant was talking too much. Talking too much when stopped by police may raise suspicion and lead the officer to believe there are reasons to investigate. So in order to limit this, the best thing you can do is, if you're intoxicated or if you've had a drink, is to say as little as possible. Otherwise, the officer may investigate further to determine if you're intoxicated. Number 2, arguing with the officer. First of all, getting in an argument with the police at the scene of an investigation is never going to work out for you. So what you should do is have your driver's license and insurance ready, be polite, and comply with the officer when he asks for these documents. You're not required to talk to him, but starting an argument or engaging in an argument with the officer will not benefit you. In fact, if you argue with the officer may use that to support his theory that you are in fact intoxicated. Once you provide the necessary documents to the police, such as your driver's license, proof of insurance, remember, you always have a right to remain silent. You're not obligated to answer any additional questions. You're not obligated to discuss sports, the weather, where you're coming from, where you're going. Provide your license, provide your insurance. Be quiet. Don't talk too much. It will be used against you. Number 3, police officers love to claim there were signs of intoxication. Now, to be fair, the officers do receive training in recognizing signs of intoxication. However, these tests are all subjective. They're based solely on the officer's perception of what's occurring at the scene of the incident. The officers will look for physical signs of intoxication, such as slurred speech, bloodshot eyes, and they'll look for mental signs, such as confusion, inability to follow instructions, talking too much, being aggressive, starting an argument. The best thing you can do to limit the officer's reliance on signs of intoxication is to minimize your interaction with the officer. Obviously, if you have slurred speech, you should limit the words you speak. And if you have bloodshot eyes, this is often and routinely explained by many medical situations. You could have real bad allergies, you could have high blood pressure, you could be having a headache at the time that's causing you to have bloodshot eyes. So bloodshot eyes in and of itself is not indicative of intoxication. However, if you're combative, have slurred speech, is aggressive, angry, the officer will look at all of these factors to determine reasons to believe you're intoxicated. The best thing you can do to limit the ability of the officer to claim there were signs of intoxication is to limit what you do. Provide the necessary documents and be quiet. Number 4, I like to call it strategic handling of field sobriety tests. These field sobriety tests are completely subjective. If the officer wants you to fail, you will fail. I don't care if you've never had a drink in your entire life, the officer can fail you if you submit to a field sobriety test. The best thing you can do when asked to submit to a field sobriety test is to say no. Now, there may be driver's license consequences for refusal to submit to a field sobriety test. That's secondary to the legal consequences you'll face if you submit to a field sobriety test and the officer subsequently uses those results in a criminal prosecution against you. Simply do not agree to a field sobriety test. Now, if you refuse to submit to a field sobriety test, I gotta let you know that may not be the end of it. The officer may seek a warrant to draw blood. Unless you're completely opposed to needles, in my opinion, this is a better choice if you're truly sober, because the officer doesn't get to subjectively decide if you're intoxicated or not. If you're intoxicated, it'll show up in your blood. If you're not intoxicated, it won't show up in your blood. Additionally, if the blood draw is not done for several hours after the encounter with the police, your lawyer will be able to argue that these results are not reliable. They do not fairly and accurately reflect the blood alcohol content at the scene of the crash. Therefore, they shouldn't be admissible in court. Now, this argument may or may not prevail, but it's much better than admitting to a field sobriety test where the officer's subjective analysis will rule the day. You don't want that. Let's talk more about these field sobriety tests. Even if you haven't consumed any drugs or alcohol, a perfectly sober individual could still fail a field sobriety test. due to a number of reasons that have nothing to do with intoxication. A person could be nervous, a person could have medical issues that affect balance, a person could have physical injuries that limit mobility, a person could have a poor range of motion in general, a person could be a poor performer when it comes to following simple instructions. These are all legitimate excuses that have nothing to do with intoxication. However, the officers routinely use that as signs of intoxication when it comes to these field sobriety tests. So in summary, if you're ever stopped by law enforcement and they believe you are under the influence of alcohol or drugs, remember these 4 things. Number 1, limit your talking to what is required by law. Number 2, don't argue with the officers at the scene. Number 3, don't try to explain away allegations by the officer that he sees signs of intoxication. And number 4, decline to submit to a field sobriety test. If you do these 4 things, it's not guaranteed you'll be found not guilty, but you will significantly improve the chances of being found not guilty of DUI or DWI. Thank you. If you found this video useful, please like it, subscribe, and stay tuned for more videos in the future.